Okay. Welcome to this sitting. This is a special sitting, the aspect dealing with law and society, and in this case, the traditional dispute resolutions mechanisms, and that is captured within the Constitution. So we are not going to do everything, but we are going to do what we can within this short period of time, because this is a sitting that should require even extra hours, because it is going to engage us in a lot of discussions, debates, and as well as interactions. After my presentation, usually I give the floor to all participants to share their thoughts, their views, but most importantly, their experiences, so that we engage what we are discussing during this time with the reality on the ground, what you experience in the corridors of justice, and how our laws do what we are looking at. First and foremost, I want to open up by giving you a general quick overview of law and justice, because here we are treating an area that is specifically on the area of justice, and especially the administration of justice in terms of processes. When we talk of mechanisms, we are looking at processes. However, still we need to admit also the reality of our changing social reality, social scenario, our dynamic society in terms of growing economy, but as well as growing population. And there is social mobility as well, because many people move from the rural part of our society to the urban part, which is becoming metropolitan, for instance, Nairobi, Mombasa. And all this brings a lot of questions when it comes to the area of the administration of justice. Well, when we address this topic, the alternative dispute resolutions, and within the context of alternative justice system, we need to admit that it is not only a reality in Kenya, it is a global reality. It is a global reality because even in the United States of America, in Canada, in the United Kingdom, in many European states and many African states, including South Africa, the reality of law and justice is continuously changing, and we need to admit that the question regarding the alternatives should not be something new, even in the area of litigations, public interest litigations, or the ordinary traditional litigations that we are faced with as practicing lawyers in court with the parties and the bench. So all these ones are grouped together to explain to us the concept of alternatives. Alternatives simply means choices or other avenues or other possibilities. And it should also be seen with the backdrop of what is known as the formal state law or the substantive judicial system as it is defined within the Constitution of the Republic of Kenya. Now, the alternative dispute resolution, we are talking about other avenues in which certain disputes could perhaps be resolved. And this one is not excluding the formal judicial justice system, but it is proposing something that we refer to usually as extrajudicial dispute resolution mechanisms. Those ones are areas in which people or parties, the aggrieved parties, resolve their grievances and complaints without going through the formal court procedures. that are very technical and take some time, but also cost individuals some amount of money. It may not be so much, but there is something that we again look at when we consider the constitutional doctrine under Article 48, the access to justice, in which we read that the state shall ensure access to justice to all persons, and if any fee is required, it shall be reasonable, and it shall not impede access to justice. If we read this doctrine between the lines, it takes us to Article 159. Article 159 is epitomized under the judicial authority, and it is predicated on promoting the access to justice by opening up to other alternative dispute resolution mechanisms or avenues or forms. So before we get and engage into this discourse, I want us to agree that it is about our judicial system and understanding the ever-expanding area of the legal service in terms of offering legal services to parties, to individuals, and that is the work, of course, for attorneys, for advocates, and for lawyers. And in that case, lawyers have got so much to do together with the other judicial officers. And here we are talking in terms of honorable judges and magistrates that always sit to deliberate over different issues involving different parties. Before we get into the nitty-gritty and detailed explanation of this issue, I want to refer myself to a quote from a jurist from South Africa, Nkosi Mahao, who published a journal with the title African Jurisprudence Exhumed. And this has been published by the Comparative Law and International Law Journal in South Africa back in 2010. And there is a phrase which is very important for us, and we should engage in this. Never, ever refer to a bushman as just a bushman. Well, this should send certain important signals when it comes to the starting point of the missing element when it comes to our engagement with the African jurisprudence and especially the traditional dispute resolution mechanisms. And we need to engage before anything else with what is the substantive problem. The substantive problem, to begin with, is related to the social cohesion. The social cohesion in multi-plural and developing societies, and Kenya included, is creating a very, very wide gap that needs to be filled. And that gap is the gap dealing with the understanding of justice, but mostly how justice is administered. And this is also with the backdrop of the doctrine of access to justice, so that each individual should not fail to access justice expeditiously. And if anything, the state should facilitate. Another area that we miss whenever we address ourselves to issues of justice is that when we say the state shall ensure, what are we referring to as the state? Let's again disengage our thinking from what I would call the layman's thinking out there, that the state is equal to the government. The government is just one of the state organs, which has got the executive power to manage the state affairs. But the state involves the populations. The state involves the territory. So we need again to read this together with Article 1 of the Constitution, that the sovereignty of the state is with the people. And it is the people that can delegate such powers to their representatives. Those are members of parliament or the elective positions. But also the people themselves can exercise that right, which is constitutional, by directly engaging in discourses that on issues that affect them. For instance, the question of coronavirus, the global pandemic, or any other issues such as corruption, or things to do with conflicts, or maybe some crimes of tall order. So it is that engagement that puts us to the understanding of the alternative justice system. That means another way of looking at justice other than relying on what is known as the formal justice system in terms of our court system, but looking at other areas. The reasons underneath all this is cynical democracy, that is the insistence on issues such as democracy, human rights, the rule of law, and the neoliberal kind of thinking and understanding the society and its dynamics. Now, there is also unrelenting economic turmoil worldwide, in which you see people displacing themselves or changing their locations. For instance, in Kenya, people from the rural sector moving towards the urban sector, maybe for search of happiness and better life. So this kind of movement of people and mixing up of people is one of the key reasons why we address ourselves to the alternative justice system. We will deal with that again separately. Now, the unstable political terrains also, we look at it from a wider range. This is a worldwide issue. It is not only in Kenya, but also we see similar scenario or circumstances in even the highly developed countries or the powerful nations, such as the United States of America. So many of such changes and instabilities can also call for certain alternatives, and that is also in order. Now, the constitutional jurisprudence, such as ours in Kenya, is also calling our attention to other mechanisms that would enable all persons or every person to access justice, because this is part and parcel of the Bill of Rights, or what Kenyans and the entire citizenry must enjoy without some procedural technicalities, as the law puts it. Now, this is bringing with it a lot of questions. What are we referring to, especially here, as traditions? What should guide our thought is the case in 2013. That is the case known as the Republic versus Mohammed Ado Mohammed. And in this case, it involved murder. And the defendant was arraigned in court on murder charges. And in that case, in the process, it came to our understanding that a lawyer holding brief on behalf of the family of the victim moved to court and asked the court that that case was to be withdrawn because the victim family and the family of the defendant have settled the matter extrajudicially using the traditional dispute resolution mechanism. So this one still remains as precedent in our country today from 2013. This case has been referred to by different legal academics and scholars as a substantive case scenario in which the court was made to believe that there are other avenues through which parties can settle their disputes without going through the technical court process up to its logical conclusion.
Daktari, thank you for that insightful presentation. And I must state that I think in my mind, things are more clearer than we began. I am aware that in the AJS policy that was launched recently, there is a proposal that since these practices, alternative justice mechanisms are being practiced even currently in our courts, and that amidst the confusion on how the court should be handling these processes, every court has devised its own way of dealing depending on what practices are being embraced within the environment of that particular court. There is no uniform way of doing it nationally. And there is a proposal that these processes should not be left to the choices of parties who are before the courts or who come to court, that it should be the decision of the court to find that this matter is suitable for referral if it is already brought to the court, or that at the inception of the court, and I know that some of our colleagues already know how the mediation processes are taking place, that files are just sampled out and it is established at the court registry that this case is suitable to go for mediation. Parties are not given a choice, but in some forums like arbitration, parties have to submit. So do you agree that this idea of submission into the process of alternative justice mechanism should be withdrawn so that parties have got no control? They cannot consent to it, but this authority is given to the court to determine that this is suitable for alternative justice and refers. Secondly, I would also wish to establish whether human rights advocacy are fully embraced issues of alternative justice, because I think that is where the issue is thorny, because they are seen as like violations of human rights will take place more if disputes or if cases are resolved outside, and parties, and I think even the public, feel safer in the mainstream, in the formal justice system.
I find it very informative, and it is more of a comment than question. Yeah, I can only add one or two things. I concur fully with you when it comes to the court stamping its judicial authority on matters dealing with traditional dispute resolution mechanisms. The reason for which this kind of argument would make sense is that once we leave the issues of justice without any authority or any control or any possibility of appeal, then things may get out of control. And I don't want to say that it is the court to tell to the parties or to defer those matters back to their traditional community setups, but it would be like the court to work in tandem, to work concurrently with the communities. How to do this is a question of addressing the issue I mentioned about the traditional leaders, because until Kenya would identify traditional leaders and also endorse them within the constitution for more protection, it would not be easy even for the court authority to know who to refer the matters to.
Thank you so much, Daktari, for your wonderful presentation. And mine is more of a comment. And I'll wish to say that the alternative dispute mechanism, I think it's a good process in the sense that there's no win-lose. It's a win-win situation. And I wish to comment on the case that you have just cited, Somebody Republic versus Somebody Mohammed. I think in such a case, if people are allowed to have their own issues resolved amicably, then there'll be no win-lose situation. They will go back to the community and live happily, knowing that the issue has been resolved by agreeing between the communities. Other than if it went to court.
We have not heard the voice of Watima. I will pass the baton to her to give the vote of thanks. Caroline.
Incredible. Thanks so much.
Oh, wow.
Wow.
Daktari, thank you so much for your presentation. I have not spoken because I think your presentation was very informative, and my classmates have said it all. Further sentiments might just dilute everything. So I agree with whatever that has been said, and we will keep on discussing through the YouTube, whatever that you have shared. To thank you, Daktari, so much for talking to us, for teaching us, for taking us through that course. Most of us are interacting with ADR in our day-to-day activities. Most of us are legal practitioners, judiciary, ODPP, and these are things that we do every day. So, umetuchanua Daktari, we appreciate it. We hope that we will keep on interacting.
Thanks so much, Caroline. And I want to appreciate all of you and each one of you. Also to appreciate those who could not attend this important meeting. If there is no substantive issue to be discussed, I want to believe that we can hang up.